Hi, Allison. How are
Hi,
you?
I'm good. How are you?
I'm fine, thank you. Always
Good.
nice to
Oh, we're
see
about to
you.
be joined by our feline friend. Be warned.
Oh, well, that's nice. Always nice to have a cat company.
Gus has thoughts.
They were part of the series, so it's very nice to see them on the
Yeah.
final part. So we're continuing here with the sex assault series, and this one is actually also quite important because we're going to be talking about some of the tactical issues that a defense lawyer should be mindful of. And I think it's some of the questions that many of us have when we're dealing with these types of cases. So we're going to be covering whether it is good or bad, or what's better to go with a judge and jury or a judge alone trial, OCJ versus SCJ, whether the client should testify or not, and any other points that you want to raise. But those are some of the most important points and questions that any defense lawyer and client will want to consider when they're dealing specifically with a sex assault case
Yeah.
more than any other case. So let's start then, Allison, with um, what kind of trial should we go for, judge and jury or a judge alone trial?
I think that's probably one of the most hotly disagreed upon issues in
Yeah,
criminal law is whether you have a jury for a
I
sexual
agree.
assault or not.
Yeah.
Um, I, for a long time, was very much of the view that judge alone is better.
Hmm.
Um, for me, that was for a couple of reasons. One, especially during like the height of the Me Too movement, I just was petrified of juries because, believe the women, et cetera, et
Yeah.
cetera. That was part of it. And then part of it is sexual assaults almost always come down to credibility analyses, right? And so my thought always was if a judge is going to convict, he's going to have to explain why, X, Y, Z inconsistencies that I put to the complainant didn't leave him with a doubt. And why my client's evidence didn't leave him with a doubt. And it always seemed to me that that was going to be, in most of these cases, very difficult to do because either there's a lot of credibility issues with or reliability issues with the complainant, or your client has testified and there's no particular issues with either one, right? In which case the benefit of the doubt has to go to the accused. So my view has mostly been judge alone is better, but there are definitely cases. First of all, not everybody agrees with me on that, but second of all, there's definitely cases where um, it's sort of I mean, juries, we can't say, certain twin myth reasoning and that sort of thing to a jury or to a judge. But a jury can think it, and I think that is always going to sort of weigh into things. So, a lot of people will think for that reason, a jury is better, at least if you've got, one of the 12 of them thinking, I mean, let's be honest, inappropriate things about the complainant and
Yeah.
or her story, then that's all you need. So there's pros and cons to both. Although for child sexual assaults, I would never go anywhere near a jury. I don't
Hmm.
think there's ever a case where you want a jury hearing a sexual assault of a child case. Adult complainants, I can see it both ways.
One of the things that and again, that's my own personal feeling that I've been getting recently in sex assault cases, and it is true. I mean, the point that you raised, the Me Too movement has had a big impact on these trials. But one thing that I have been feeling is I feel like there's a little bit less of common sense that we see coming from judge alone, just because it's very much rooted in the law. And unfortunately, it seems like the law is making less and less sense. So we're going away from what makes common sense, and we're just looking at these very theoretical legislated
Yeah,
rules.
yeah,
Whereas the juries, I feel they still will kind of rely on common sense.
yeah,
Um, and that's why my feeling has always been that if your client has a story that makes sense, it's
right.
a simple, common sense story, I feel like this is something that should be put to a jury because they will be able to connect with that. They will
Yeah.
understand that more than a judge. But I don't know what you think about that, Allison.
Yeah, I agree with that for sure. And I will say every sexual assault I've ever done with a jury has been an acquittal. So there's definitely some truth to that, I'm sure. Um, I guess the one of the things I would always come back on, obviously, acquittals is your number one goal, but you should also always be sort of thinking with a view to appeals and
Hmm.
potentially grounds of appeal. And I've just always found it very difficult to understand, at least on the cases I've done, how a judge could possibly explain being convinced beyond a reasonable doubt in these things. And if he did, surely there was some sort of error there that would be open to appeal. I don't know if that's true or not, but there's every case I've done with the jury has been an acquittal. So they tend to get it right.
Yes. And do you think how much does your client have an impact on that decision? Like, do you also take into account what your how your client presents, his personality, the way he speaks, the vibe that you get? Because I honestly, I feel like there are some clients I kind of don't want to put them before a judge alone or before a jury. So does that also get come into play?
Definitely. Yeah. I
Mhm.
mean, if your client is like creepy,
Yeah.
don't have a jury.
Yeah.
That's my view anyway. Yeah. So yeah, it definitely does. And if they're if they're good at testifying and they're good at speaking and they're good at presenting themselves, that's good for a jury. Whereas it matters less, I think, with the judge.
Yeah.
So yeah,
Agree.
that factors in for sure.
Okay,
Yeah.
so that's also one of the things that should be taken into account. It's um, the story, the defense itself, like what your client says about what the defense is,
Yes.
how the client presents as well is something that should also be taken into account. Now, what about the complainant? And also, what about cases where there are multiple complainants?
Multiple complainants. Gosh, that's tough. I mean, those are usually more in sort of the human trafficking area, I think, than regular quote unquote sexual assault. But multiple complainants, my concern would be that a jury would engage in propensity reasoning, whether they're, told they can't or not. So, unless you have, for example, in a case where you have obvious evidence of collusion, that might
Like
be a thing for
Gomeshi,
a
for
jury.
example. Yeah, but
Right,
that was a
exactly.
judge alone trial. Yeah.
Yeah. I think that might be okay for a jury. But as a general rule, I think multiple complainants generally should be kept judge alone
Hmm.
because a judge is going to have to caution himself, obviously, unless there's a successful, similar fact application or something that there was no collusion. And, he'll have to analyze each one separately. Although, as I'm saying this, multiple complainants, generally speaking, I would think that those should be severed before a trial anyway. Unless there is obviously a similar fact application that the Crown is going to be successful on. I can't imagine many cases where you'd keep the complainants together without bringing
Hmm.
a severance application, unless you had obvious evidence of collusion.
Yeah. Okay. So the next question then is, and that's also another tough call, is should the trial take place in the Ontario Court of Justice or should it be in the Superior Court of Justice?
Well, I mean, obviously, to state the obvious, if your client wants a jury, then a superior court it is. But otherwise, I mean, it's funny. I just did I was at the young lawyers. Is that what it's called? The Young Lawyers
The
Conference
recent
at
call.
UCLA? Recent
Yeah.
Calls Conference. Yeah, today. And the panel I was on was all about elections. So we got very much into this. But um, honestly, depends where you have a better bench.
Hmm.
That's the honest answer. Go where the better defense-friendly judges are.
Yeah.
If you don't know the jurisdiction, ask around which bench is better. But in many jurisdictions, one bench is decidedly more defense-friendly than the other. So that's where you want to elect.
And you're based in Toronto,
Yes.
Allison. So where do you usually have your trials for sex assault cases? What's your tendency?
For straight sex assaults, simpliciter, so to speak, OCJ, I usually
Hmm.
go with. For anything where there's preliminary hearing eligible counts, such as, interference or some of the human trafficking counts that sometimes go along with sexual assaults, those I generally go to the Superior Court because I want a preliminary hearing. So if it's just a sexual assault that's not preliminary hearing eligible, I generally stay in the OCJ. If I have the option of a prelim, I always, always, always take it because these are
Okay.
credibility-based cases. So if you get a chance to cross-examine them before the trial, hallelujah. In those cases, I go to Superior Court.
Okay, and so that's another important point that people should consider is if there is an option, like a sexual interference case, where you can have a prelim. So your advice is have the prelim. You should, yeah,
100%, 100 times out of 100. Well, I mean, we talked about this morning a bit too. I suppose the exception to that would be, if it's truly a child witness, like if you've got a 5 or 6 year old
yeah,
complaining, you're probably not going to get very far with, impeaching them with a prior, transcript. You're not going to win, as Adam Weisberg on the panel this morning pointed out, you're not going to win many points with a judge by trying to impeach a 5 year old with their prelim evidence. So, for a very young complainant, maybe not. But many of these cases, if not most of these cases, are historical, right? It's something that someone has reported years and years later when they're a teenager or even an adult, in which case, yeah, have a prelim so that you've got a version of events you can then impeach them with at trial.
okay. And then the other important point, and I think this is probably the most difficult decision ever, is whether or not the client should testify. I think the trend now is really to put the client on the stand because, I mean, the evidence in most cases, putting aside when there is DNA and there's
Mhm.
scientific evidence, independent evidence, but when it's a case where really it boils down to credibility, what she says versus what he says, or depending on the sex, it's not always he and she, like it could be
Yeah,
he, she. Um, so in those types of cases, it's kind of there is no choice but to put the client on the stand.
that's my view. Like leaving
Mhm.
aside the burden of proof, blah, blah,
Yeah,
it's not, you got to put your client on the stand, particularly in obviously a case of consent, which most of these are.
yeah.
At least most of the ones that I do, they end up being a case of consent. So, and you can't, you have to call evidence of consent. And the complainant's not going to get up there and say, yeah, you're right, I consented. And so it's got to come from your client. But that's the reality of it. Burden of proof aside, the reality is that your client has to take the stand in very, very many sexual assault cases, if not most.
But what about the cases, and those are a little bit d more difficult, they're trickier, the ones of the mistaken belief and communicated consent, when the accused has to ascertain and make efforts to know what the age of the complainant was. Like, this is, I mean, usually, because to be honest, I find the law here in this area is really, this is one aspect of the law that doesn't really make sense. Like, is someone really gonna ask all these questions that, like, in that particular situation, in the heat of the moment, and start asking just to make sure that they comply with the law? Like, I find it ridiculous, to be honest.
I agree.
But like, how do we deal with that when you want, like, the client has to explain what they did to confirm the age and that they did everything they can? Like, this is a very difficult and messy area of the law.
It is, and it is a bit ridiculous. Like you don't climb into bed and say, "Oh, can I have your driver's license, please?" I
Yeah,
mean, who does that?
exactly.
Right? Yeah, I know it's silly, but you know, often you don't have to be looking at somebody's ID, right? You can, it doesn't have to be necessarily quite that specific, but there do, and you only have to take these steps, by the way, if you sort of have a doubt in your mind about the age, right? So, um, things like. I don't know, looking at their social media and, seeing that they're at college parties or, there can be lots of examples of things that you do that wouldn't be sort of weird or odd to explain because if you have to take the steps to confirm age. But if you stand up there and say, yeah, Your Honor, before we climbed into bed, I asked for her driver's license, everybody's going to laugh at you and your evidence is going to be rejected anyway, right? Because who
Yeah.
does that? So you're
Yeah.
right. It's a messy area of law. Uh, so that, that may be an exception because complainants generally aren't going to openly admit that they lied about their age, right? Like that's something they're going to be a little bit
And
skeptical to
many
admit.
women do lie about their age,
Right.
regardless, even if it's not about sex assault. Women just don't in general. Like it's a very kind of sensitive area to ask a woman about her age. Many feel offended, don't like to
Yeah,
tell
I
their
mean,
age.
I'm getting to the point that I'm going to start lying in the other direction. So yes, true, but that's true. So you may be able to get admissions out of the complainant that, yes, I told him I was 18 or, whatever would help you. And then maybe you don't need to call him. If it's just a matter of if it's not if the complainant's evidence essentially is yes, I consented, but I was 15, then if they admit to lying to their age, obviously you don't need to call the client.
Hmm.
That's the end of the case. So yeah, it's a difficult one to assess, but um, I can't. I mean, I've done, gosh, dozens and dozens and dozens of sexual assault trials. I quite literally can't remember the last time, if ever, I've run one without calling my client.
Yeah. I
So
think this is the tendency that we're
yeah,
seeing right now. They have to present their side of the story, and they have to also explain, like, especially in the consent cases,
yeah,
how they generally believe that there was consent.
yeah.
So, I mean, I know we did talk a little bit about that when we were talking in the episode about preparing the client.
Mhm.
We got into more detail about that. But then also, what are some just some more points that maybe you want to talk a bit more about on this area of the client testifying as well, like some other points?
I mean, I'm sure I probably mentioned this last week. I think I did, but the most important thing that they have to be able to do is explain why they believed the complainant was consenting.
Mhm.
And often, I mean, you can, when you're doing a dry run of their evidence with them, they can say, yes, we went to Moxie's for dinner, we went and saw this movie, like the easy stuff. But then when you say to them, what made you, I guess, believe she was consenting? Um, they look at you like you have two heads and just sort of stutter and say so they have to be able to articulate that so spend a lot of time focusing and explaining to them the law of consent, helping them be able to articulate why they thought it was consensual in this particular case. She undid my zipper first, she took off her pants first, whatever the case may be. They've got to be able to articulate that or they're in big, big trouble. And show that they understand consent because every cross-examination in a sexual assault trial, you're going to hear the Crown say, you didn't really ask her, sir, right? You just assumed she was consenting. And the inclination of many of our clients is going to be to say yes and agree with that, which is deadly. So you've got to spend a lot of time hammering the actual law of consent home to them and getting at it, getting their heads out of the sort of, I mean, day-to-day common sense, stereotypical ideas of consent that we all sort of have.
And Alison, I know we talked also a little bit about that, about the approach, the style. Like when we were talking about the complainants, for example, we did mention the fact that it doesn't really help if we're aggressive with them, especially when we're dealing with a younger complainant.
Right.
You're going to be able to get more information out of her if you're actually more neutral, more professional in your approach. Now, the other thing, and that's also from a strategy point of view, or just in general, when we're dealing with a jury, like what's the style and the approach? Because it is very different when we're before a jury. So, what advice do you give to lawyers in these types of cases? Because the other thing is that not only when you're dealing with a jury, it's different from when you're dealing with a judge, but we're getting into areas that are a bit uncomfortable for everyone.
Mhm.
Like it's uncomfortable for the client. We're asking questions that are embarrassing for the client, for the
Yeah.
complainant. We don't like, even for us asking these questions. I mean, like it's a very, weird thing to be doing. Only a criminal defense lawyer can understand. But again, when we're before a jury, what are some of the, what advice do you give to lawyers, especially those who are doing these types of trials for the first time? What advice do you give them when they're before a jury in a sex assault case?
Um, First of all, same thing. Don't be mean and nasty. You're
Hmm.
not going to win points with the judge, and you're also not going to win points with the jury. I mean, I'm sure, at least one or two of the jurors are going to know somebody that's been a victim of sexual violence, right? To some extent, and it's never going to get you anywhere by being overly nasty. Don't don't just redo the crown's chief for them. I see it so often, and you're, sitting there watching a cross-examination, and it's basically just repeating all the same questions that the crown asked in chief for no discernible reason, other than hammering home the complainant story yet again. I mean, that doesn't get you anywhere, right?
Hmm.
Be focused, make it seem, even if it's not true, that you've got a defense here, you know exactly what happened, her version isn't correct, and just get to the point. Um, you know, Obviously spend some time if there's a prior statement, pointing out any inconsistencies or anything like that. But otherwise, be focused, be confident, and don't just dilly-dally repeating all the Crown's questions, which is something I do see a lot. And it's not helpful. It's just reinforcing the Crown's case. I think those are the two most important things.
And if you want to just zoom in a bit on this confidence issue, because that's sometimes the most difficult part, especially for someone
Yeah,
who's new in a jury trial. It is nerve-wracking when you're before a jury, and it's sometimes not easy to show confidence.
yeah.
But here again, like how important is it actually in front of a jury as opposed to in front of a judge?
Um, it's important for both, sort of for different reasons, I think. And when I say confidence, I don't necessarily mean
Not arrogance.
not arrogance and not even like self-confidence. I mean more confident in your case. So, like for me, um, in every trial I do, I make every possible admission that I possibly can. And I make an issue only out of the one thing that is an issue in that trial. And when you do that, you're portraying a sense of confidence in your defense to the trier of fact, whether it's judge or jury. Like, for example, and I seem to have a niche practice of self-defense homicides. How this happened, I don't know, but I've had like five in a row. Um, Sometimes I admit so much of the Crown's case that, the whole trial lasts like a week, a homicide trial.
Hmm.
You don't need to hear from, 50 SOCO officers and, the arresting officer and the pathol. You don't need to hear any of that. You admit much of the Crown's case and you just focus on the sole issue of self-defense. Same thing for a sexual assault. You don't need to make an issue out of everything. You don't need for the Crown to call the officer who took the injury photos and the officer who arrested your client and the officer who was with the complainant at the hospital for the sexual assault kit. Admit everything you can admit, and it portrays a sense of confidence in your defense. That's what, when I say confidence, for the most part, that's what I mean. And by the way, by doing that, kind of helps with your own self-confidence as well, right? You don't have to worry about, 50 different witnesses and, drafting 50 different You just focus on the one thing And the message it sends is that this woman knows her case, right? And that is effective to judges and juries. Juries, I mean, I suppose both. They don't like their time being wasted.
Yeah.
They don't need to hear, days and days of evidence that they later are told by you is completely irrelevant, right? So
Yeah.
be focused.
Well, and I think the worst thing that can happen in a jury trial is when you need more time, right?
Oh
Like
yeah,
when you're in a situation where the time that was scheduled is not enough and you're trying to look for more time, that's a nightmare in a jury trial in particular.
yeah.
I just want to go back to a couple of points here also on the jury choice. Um, because it seems also like sometimes what some lawyers will do is that when there's a very weak defense case. Sometimes the option is, well, let's just go before a jury because, like at least you have 12 people who are going to have to be unanimous. So is that
Yeah.
also something that, especially in a case, I guess, when the client doesn't want to plead guilty and there
Yep.
really is overwhelming evidence against the client, then maybe a jury option here is better.
Definitely. Yeah, I agree. It's like your Hail Mary defense.
Yeah.
Yeah. Just pray that one of them is, a masochist or something and will, not care what the evidence is. Yeah, definitely.
Okay.
There's merit to that.
All right. And just again on the how a lawyer should be in front of a jury trial, just because, I mean, we recently had the Hockey Canada trial where we saw that
Mhm.
there were a few issues that came up here. We don't really have too many details, especially the first time around, but it was very unique where in
Mhm.
that case, there were two juries who ended up being dismissed because there were some complaints about defense. Let's talk a little bit about that because it seems like that was very problematic in that case, and it ended up being a judge alone trial, which ended up being better for the defendants in that case.
Yeah.
But if we talk a little bit about that, because that could also be an issue that comes up in the future.
Definitely. I mean, juries are always watching you.
Hmm.
Remember that they are always watching you. Like whenever I'm doing a jury trial, I always say I drive like a grandma within 10 blocks of the courthouse, right? Because
Okay.
I tend to have a bit of heavy foot. I might not always be the most safe driver.
Yeah.
I'm always in a hurry, but when I'm near the courthouse in a jury trial, I don't want to be tailgating or honking at a juror, right? So
Yeah.
I suddenly turn into grandma anywhere near the courthouse. So yeah, they are always watching you. And I think that the Hockey Canada trial is sort of a good example of, the belief was, and I don't know if there's merit to this or not, but that the jurors may have been somewhat upset with how some of the defense lawyers were handling the complainant. There was certainly that thought, and that sort of goes to what I was saying, and I don't know if that's true or not, but it sort of goes to what I was saying, which is that it never does you any good to be mean or nasty or hurtful or abusive to the complainant. You're not going to win points with a jury that way.
Yeah.
And I think some of the complaints in that case allegedly were about, that they thought the lawyers were laughing at them when
Yeah.
they came in, one team of lawyers in particular. First of all, I highly doubt that,
I
but
know, I
um,
agree, especially when they mentioned that particular team, which
yeah, I
I
know
know
them
are
both very well.
very,
There's
yeah,
no chance that that's
no
actually what
way
was
they would want to
happening.
do this.
No, but I mean, it is a lesson that, the jury is always watching you. So, the minute you hear that bell or knock and the jury's on their way in, pretend you're in church. Like, do not
Yeah.
do anything that could potentially offend anybody. And, I'm always, for example, when in a homicide trial, if it's like a family member of the deceased or something that's testifying, just be nice and respectful and show that you recognize that a life was lost here. Same thing with the sexual assault. If a lot of these cases, consent cases, for example, are, you know, it's probably somewhere in the mushy middle. A night out at the bar, some regrets the next morning, who knows what really happened, but whether there was consent or not, much of the time the complainant has obviously been traumatized, whether by reasons of what happened or by something in her own head or by something in her past. There's a reason that this was made into a criminal case, right? Um, and if you're disrespectful of that and not cognizant of that, you're going to offend some of the people on the jury. So that's what I always tell myself is, you know, regardless of what happened on this particular occasion, something most of the time has happened in this woman's past or in her mind due to mental health issues or whatever that's put her on the witness stand. And I should be respectful of that. I should do my job and do it well, but I can do that without, re-traumatizing somebody who's obviously been through something.
And I think, in parallel to what you're saying here, Allison, it's also important, as much as possible, I think, to limit, not limit, but not to really have very long cross-examinations. I find personally, like when it's super long, it
Yeah,
becomes counterintuitive. It's bad advocacy. You really
I
have
agree.
to go straight to the point. You don't have to have, like, a good cross-examination is not a long, a full day cross-examination of one witness. I mean,
Agreed. I
eh,
couldn't agree more. My mentor, my first mentor, James Lockyer, he always said the best lawyers are the ones that know when to sit down and shut up. And that is absolutely true. I conduct every case like that. If I'm more than 5 minutes in a cross-examination with almost any witness, something has gone sideways because
mhm.
I quite honestly, like I'm in week 2 now of a Superior Court trial starting tomorrow, and I don't think I've asked more than 10 questions the entire trial. You know your case, get to the point, and sit down.
Right. And I mean, obviously, there are exceptions when we're dealing with a case where there are multiple incidents, multiple dates. Of course, it's going to be longer because you have to
Yeah,
cover all the events. But in many of the sex assault cases that we see, it's usually one night. They don't know each other. There's one
right.
incident that happened. I mean, it doesn't have to take days to
Oh God.
cross-examine the complaint. I mean, I remember I had a JPT where we were trying to get time estimates, and the judge was telling me, "So how many days do you need to cross-examine the complaint?" And I said, "I was thinking maybe an hour max, Your Honor." So I
Exactly.
was
Yes.
surprised that the judge was expecting days of cross-examination. I'm like, no.
No, no, you are 100% correct. Otherwise, you're just going in circles and giving the complainant a chance to repeat her story 1,000 times for
Yeah,
absolutely no reason. Yeah, no, bad idea. Be focused. I at the beginning of any sexual assault case, for example, I have my chart with, everything the complainant said to the police and then the answer in the second column. And after they've testified or as they're testifying, I go through it. And if the answer they've given on the stand is the same as in my chart, you can cross it off. You don't even need to go there,
yeah.
right? So, you just focus on the inconsistencies. You don't get her to repeat the rest of her story. And then obviously, the Brown and Dunn cross or whatever else you've got to work with. But no, be focused and be brief. No judge likes their time being wasted.
And the
And they will
same,
take it out on your client.
yeah. And the same goes to before a jury trial. You want to be even more focused, I think,
Yeah,
because then they will get bored. You will lose the juries, and it's always better when it is more focused.
yeah.
So, what else? What are some other strategic points that lawyers should be mindful of for these types of cases?
Oh
So,
gosh.
we
I
covered,
mean,
yeah,
if it's not possible in every case, and I don't think it's maybe as important as some lawyers do, but if you've got, try to think of a motive to fabricate.
yeah.
If you've
I
got
agree.
that,
So, to be
oh,
honest, I think it's very important in these cases, especially in the case where the complainant and the accused don't know each other.
yeah,
I feel like this is a question that's going to bug the trier of fact, whether it's a judge alone, hi Gus, or a judge and jury. I find if you can't explain, like there has to be a reason why they will complain because it's a gap. I feel like as human beings, our brain always is always trying to understand, well, why is this happening? So
Right.
why would a woman who doesn't know a guy who just had one encounter with him is going to like what is she going to gain? Unless you can, show that, well, she got paid to complain about him or there was a story. But that's an important point, I think, right?
Yeah,
Like,
definitely. Yeah. It's sometimes it's just not possible, no matter how hard you try,
yeah,
and that's okay. But if if you can put together any potential motive to
yeah,
fabricate, it's
I
really going to
agree.
help the judge. Um, think about any potential, and we sort of touched on this in previous episodes,
Hmm.
but think of potential records that might be helpful, and you can just sort of ask random questions during the middle of the trial, because you've had no chance to explore it, and you know, potentially get those during the course of the trial. But motive to fabricate, I think, is the most important one.
Yeah. I agree. Like this is really important. And again, it's especially in cases where they don't know each other, you
Yeah,
really want to explain, well, why are we here?
yeah.
What is she gaining from being here and going through this? Yeah.
And I guess the other one is don't, I mean, we all know about, the twin myths and various other myths that go along with sexual assault. I still see very, not very, um, not very well veiled references and questions that get to the twin myths, by far too many lawyers. And, in front of a jury, a judge isn't necessarily going to call you out on it at the time, right? They're going to wait until the jury's gone. Sometimes they might call you out in front of the jury, which is potentially even worse. But that really does offend a lot of people. Like if you start, and by people, I mean jury, if you start asking about, the what the complainant was wearing and how short her skirt was, and like I still see a lot of that, and it's sort of mind-boggling. So don't go there. Don't even try. You're going to offend the jury. Be very careful about not in any way, shape, or form going anywhere near anything that could offend, most of the women on the jury.
So this is actually a very tricky point, though. It is important what you're raising here, but it is tricky because I think the issue, and that again goes to the law and the state of the law at the moment. The reason why I think some lawyers would ask these types of questions, it's again the common sense, right? Because the only context I can think of is if it's someone, for example, like a female going to a guy's place late at night wearing very provocative clothing. And then it's like, well, and she says, well, I didn't go for that reason. I didn't go to, like, I was just going to chill. And then I think it's just trying to show, well, the whole vibe was getting him to believe that, like it's a bit tricky because
It is.
you
It
want
is.
to, because there's common sense at the end. Like you want to
Mhm.
ask yourself, well, why are you go, especially if it's happening in his place, not in her place. It's one thing if she's inviting him in and this is, but you're going to someone's place at a specific time, dressed up in a specific way. Like, and I know this is all these red flags that we can, but it's also like, how do you balance myth and common sense? I think is the difficulty right now in these types of cases.
I think you can say it without saying it. Like there's other ways, you can talk about her flirtatious behavior with him, for example, or, the fact that, she was, had her arm around him all night. Like there's other things you can rely on that sort of get to the same point without being too offensive in terms of, just the implicit suggestion that because you were wearing a low-cut shirt, you were consenting to sex. I mean, you have to, I think there's a line that you can tiptoe up to in terms of, you were flirting with him all night, you had your arm close to his thigh, like stuff like that without being quite so blatantly um sexist.
Hmm.
Yeah, I think that there's a few no-go areas, I think. And, state of dress and clothing, I think is probably over the line and, 99 times out of 100.
All right. So, any other final thoughts, Allison, for these types of cases?
Prepare your clients.
Yeah.
Go back to episode 3 and prepare your clients. That is the most important thing in any sexual assault case, in any case, really,
Yeah.
but particularly in sexual assault cases. And I think the thing that we tend to focus on least. So always, always, always spend as much time as you can working on that side of things and not just your cross of the complainant.
And also, like, get to know the client's side of the story, and you have to know
Yes.
it very well because this is what's going to be the basis also of the cross-examination
Yeah.
of the complainant. One thing, though, I don't know if we may not have covered this. What if the client is giving you a side of the story, and he insists, like, this is what happened, he or she, because the client could be a female as well. It's not
Yeah.
always just a male. But what if your client is giving you a side of the story and insists that this is what happened, but the evidence doesn't really support that? Like it doesn't really, like,
Oh, like in the cases where, he never had sex with that woman, but his DNA is,
yeah,
all over
for
her. Yeah.
example.
I mean, quite honestly, in a case like that, I would probably get off the record. If it was
Yeah.
that obvious. Uh,
Yeah.
but that's a tough one because you can't call evidence that you know to be untrue, right? But I suppose there could be other ways that the DNA got there. It is ultimately your client's choice whether or not to testify. We get to make most decisions for our clients or with our clients. That is not one of them. We give
Yeah.
them our advice and then we follow their instructions. So, I suppose the most important piece of advice is get written instructions.
Hmm.
I have advised you not to testify. We have discussed the reasons why. You insist on testifying. Sign here, please. Otherwise, get off the record because,
Yeah.
any appellate court looking at that, or any, potential defense appellate lawyer looking at that is going to have some questions, but it's their choice.
Yeah.
So at a certain point, there's nothing you can do. You can scream and shout and show them the evidence until the cows come home. At the very least, maybe they would agree to take your advice not to testify. But if they insist, just get it in writing.
Yeah. That's good advice. It's always to make sure, especially when you feel like there's going to be a clash and you're not you're not getting off the record and you're continuing. That's when it becomes even more important to
Yeah.
take written instructions.
Or try and get yourself fired, I
Yeah.
suppose. That's a strategy
Yeah.
I like quite a lot these
Yeah.
days. Yeah,
Yeah.
and when you've just had enough and your client isn't listening to you, try and get fired.
Well, I mean, sometimes then you can't even continue anymore. Like when
Right.
it becomes very obvious that what y the way you're going and where the way the client is going, there's
Yeah.
no you guys can't meet, then I mean, this is a clear sign that there's a breakdown at that point.
Yes, exactly. And they're never going to in a sexual assault, they're never going to be left. What I always worry about is because we know, I mean, I do a lot less legal aid now, but particularly when I had a very heavy legal aid practice, legal aid isn't necessarily going to grant a change of solicitor. And so I was always worried about, leaving a client, out in the wind and entirely unrepresented. But in sexual assaults, at the very least, there's going to be 486 counsel there to
Yeah.
sort of help them along, right? So that's always a bit potentially of a consolation.
Yeah. All right. Well, thank you very much, Allison. I know you've been giving a lot of your time over the weekends for these series, so I'm sure it's going to be really appreciated because this is a very tough area of the law. It's becoming very common, very tricky, very messy, and it makes less and less sense. So it's very good to hear from you because this is really it's one of your niche areas, safe to say.
It
So
is,
it
yes.
was a lot of fun, and thank you so much for your time over the
My
past few
pleasure.
weekends.